Good morning, everybody. Let me call our public meeting to order. Members of the public, we appreciate your joining us. Let me begin by taking a roll call of the commissioners in attendance. Commissioner Baker,
Good morning, present.
Commissioner Bluestone,
Good morning, present.
Commissioner Crispin,
Good morning, I am present.
Commissioner Hall,
Good morning, present.
Commissioner Kazarosian,
Good morning, I'm present.
Commissioner Talley.
Morning, present.
And at present, we have Commissioner Luma and Commissioner Calderon not in attendance. Commissioner Luma will be joining us shortly. We do have a quorum. Let me next ask for a motion to approve the minutes of our May 21st meeting. Is there such a motion?
So moved.
Is there a second?
Second.
Thank you. Let me take a vote on that, please. Commissioner Bluestone,
Yes.
Commissioner Baker,
Who's not present?
Commissioner Hall,
Yes.
Commissioner Gazaron, I think you made the motion, correct?
Yes.
And Commissioner Talley?
Yes.
And I'm also a yes, so that motion is carried. I turn next to our Executive Director report. Enrique, please.
Thank you, Madam Chair, and good morning, Commissioners. Let me share my screen in a minute to walk you through my report. So if you bear with me, can everybody see my screen on my report? Well, again, good morning to those in attendance as well. I will be providing my report to include a few highlights of the activities of the last month with the help of my slides, as I usually do. As a reminder to those in attendance, the Commission does not take public comment at its meetings, but we do very much appreciate when you write us with any of comments and questions by using any of the resources in the screen. Our general mailbox post-c-comments post-c-comments at mass.gov is the best way to reach us. So I will provide a certification update this morning with the latest of what we are expecting and receiving from agencies regarding veteran officers with last names I through P, which certification will be expiring on July 1. I will provide a brief update on the use of force model policy, let you know of the recent efforts of outreach and engagement, and turn it over to Eric Rebello-Pradas, who will provide the customary finance and administration update. This chart provides a high-level summary of the numbers that we are seeing relative to the recertification of many officers. As you can see at the top of this chart, the number of expected recertifications is slightly lower than previously anticipated. That's the number from last month that I reported to you. It has gone from 5,095 officers down to 5,034. The change is due to three factors, as noted in the footnote. Some officers have left or returned to policing since the last time I reported these figures. Moreover, last month, the figure included some officers whose certification was set to expire later than July 1. And now we have a lot of officers coming in from academies that have graduated at different times throughout the year. And those, to be precise in this report, those figures are no longer included in this report because I'm reporting those set to expire on July 1. So this is perhaps a good example of the fact that there are constant changes to the numbers and the applications that we see, especially around approaching the deadline of the conclusion of the certification of many officers. So as I've stated in the past, the 3-year certification requirement in the statute is a really good way to ensure we have up-to-date information on individuals licensed to be peace officers. As you can see from the other numbers, there has been quite a bit of activity in the recent month, although we still have a large number of applications that are outstanding, 2,242 to be precise. I will mention here that we are in constant contact lately with the largest agencies, notably, of course, the State Police and the Boston Police Department for these kinds of submissions because they have the largest submissions compared to any other agency, of course. And one reason for these conversations is that as part of the recertification that happens every 3 years, we require and ask agencies to confirm and ensure that any disciplinary matters regarding any officer who is being recertified are indeed submitted to post. This is another lever, if you will, that to ensure agencies like Boston, who has historically been dealing with a kind of backlog when it comes to submitting information to post, are incentivized to comply with the requirement to submit this information to us. I can report that Boston has cut in half the number of IA reports that are due to post for the group of officers in question, which is a very good, very positive development in my view. And I will come back next month to report the compliance figures as I do at the end of every quarter. Okay, so moving on to the next slide. The first training session on the model use of force policy took place earlier this month. As I have reported to you before, this is a joint effort of post staff and the MPTC. The approximately 2-hour session was well attended, and there will be 2 additional sessions at the end of this month, June 23rd and June 30th to be precise. Some of those attending included a couple of members of the Attorney General's Office Police Accountability Unit, which itself is part of the Civil Rights Division. Those colleagues have in the past provided good comments to us on the model use of force policy, as well as the regulations and certification standards that we bring to you as well. One topic of discussion as part of this effort is the fact that the model policy, the model use of force policy, discusses a number of things, including the reports that are due to post, as well as those reports that are required to be reported within the agency. There's also the next area of discussion is the fact that this policy is meant to be a model use of force policy, as I've stated in the past, with which policies for local agencies are required to be consistent with the model use of force policy. 2 things I will highlight as part of this policy is that there are also certain things, as I mentioned, what's reportable to post, what's reportable within the agency, and 2 things as part of the model policy. There's a requirement for the agency to have an annual summary of the use of force events within the agency, and there's also a requirement to provide, for transparency purposes, an annual report to be made public by agencies on this topic as well. So, as part of the training, our messaging has been that we expect compliance with this model policy by September 30th. And around that time, we will be sending a communication to agencies asking them to submit confirmation to post that their use of force policies are consistent, as I mentioned just a minute ago, with the model policy. We are not planning on asking for an attestation as we have done in the past for other purposes. We are treating this more as a survey, if you will, for agencies to confirm that what we understand is a good practice already in place in the Commonwealth. I will come back at a future meeting to report to you on the results of those confirmations. I will move on to our efforts around outreach and engagement. On May 21st, I presented to a group of Northeastern public policy doctoral students from Northeastern University, of course. I provided an overview of the Post Commission, focused on the presentation on policy matters and how those policy mandates were implemented on those early years and those early challenges. I spoke about the early days of Post, which required us to certify a lot of officers at the same time as building an agency and building an infrastructure to be able to collect all of that information. I will move on that last week, a couple of colleagues, Commissioner Talley and I, attended the National Conference for IADLES, that is the International Association of the Directors of Law Enforcement Standards and Trainings. In other words, all other posts around the country. This conference took place in Fort Worth, Texas. And as in prior years, there are useful sessions and good roundtable discussions on the topics that affect and are most interest to agencies like ours, including also not just post directors but academy directors as well. Finally, I will mention that just yesterday, just this week, I was in front of the major city chiefs to also talk about the model use of force policy and recent updates of Post. These are always a good occasions to get questions from chiefs around our activities and the compliance required. Finally, I will just highlight the training session that I mentioned earlier that took place in Holyoke for the model use of force policy. Attendants and presenters included Heather Hall, Annie Lee, and Gina Joyce, who joined other colleagues at the NPTC as part of this training. There are two more sessions, one in Marlborough, taking place, as I mentioned, on June 23rd, and one in Randall at the end of the month, which will be recorded and then made available for agencies to then consult at any time in the future. Let me pause here and turn it over to Eric Rebello-Pradas, who will give you the finance and administrative update.
Thank you, Enrique. We are now in the conference committee phase of the budget development process. The conference committee was appointed on May 28th. So our budget appropriation is technically in conference as the House and Senate numbers are different. We have already reached out to the 6-member committee to advocate for the higher appropriation. We will monitor the next steps in the budget development process. That is the release of the conference committee report, which could be at any time, I'm assuming closer to July. Of course, the governor's vetoes after that. And then we are already in the process of preparing for spending plans for FY27. For FY26, with the closing of FY26 approaching in less than 2 weeks, we revised our spending estimate upwards by about $125,000 from $8.48 to $8.61 million. Now, as a result of that, our reversion estimate was lowered from $425,000 to $300,000. And we have already informed A&F of this new estimate. So that's good. We're going to be reverting less over to the general fund. We recently met with the Internal Control Working Group to finalize updates to our internal control plan and should be publishing the updated plan by June 30th, end of the month. And F&A met with the legal division and executive director to review the comptroller's annual internal control certification submission. And that was actually due on Monday, which we have already successfully submitted. Thank you, Enrique. We've actually had quite a few staff changes. So for our human resources update, Aaliyah Spring was recently promoted, to the role of communications director. As you know, Aaliyah had assumed the director duties some time ago and has now officially assumed the role. Formerly the senior intake coordinator under the Division of Police Standards, Laura Martin has assumed the new role of senior intake specialist. In her new position, she will focus on disciplinary records, especially adjudicating requests by officers and law enforcement agencies. The legal division has a new member. Ben Robbins has joined us as the Information Management Counsel and Records Access Officer. And we also have some new interns also for the legal division. They are all from Boston University Law School: Quincy Kaysen, Sarah Crawford, Connor Hamill, and Chioma Ohodama. Right now, we have one open position, the sixth intake coordinator position. So as a result of that, we will not achieve our headcount at 55 by the end of this fiscal year, which is in a couple of weeks. So we're currently at 54, and we'll stay at that number until June 30th. And then once we start to get into spending plans for FY27, we will reassess, revise our numbers, and see where we're going to go for the next fiscal year. We do know that we will have a specific emphasis on staffing up for the audit part of the division and certifying law enforcement agencies. All right, thank you, Enrique.
Thank you. Let me stop my share and see if the commissioners have any questions or comments.
I don't think I see any hands in the air. I do want to note that Commissioner Luma has joined us by phone and will eventually be part of the video as well. Let me thank those who have just spoken to us and those who have worked with you on the matters that you have brought to our attention. Let me also welcome our new interns and those additional members of our staff and those who've been promoted. And I think with that, we move on next to our legal update. And let me turn to our General Counsel, Randy Ravitz.
Thank you very much. I will share my screen. Okay, can you see the presentation?
Yeah, we can see page. Yeah, we can see the cover page.
Thank you. This is a presentation on a proposed set of regulations that would be 555 CMR 3, and it would be entitled Law Enforcement Agencies, Officers, and Functions Subject to Regulation. And the draft of that set of regulations is included in the Commission's meeting packet. I'll provide an overview of what this set of regulations is intended to do, what the impetus was for drafting it. It is intended to define and elaborate on certain concepts that have relevance throughout Chapter 6E and Commission regulations. So in other words, it would be a set of regulations that has applicability to all other regulations and to all provisions of Chapter 6E. And it would combine certain things that either the Commission has already approved or that have been presented to the Commission and the Commission has not yet approved. So more recently, we have presented certain sub-regulatory policies, so policies that wouldn't have the force of regulation as we propose them, and they were put before the Commission but have not yet been adopted. Then there are some other sub-regulatory policies that the Commission has adopted. And there are some regulations that have broad applicability. Again, they apply in a wide range of situations, but they happen to be housed in one set of regulations where they might be overlooked. They might not be consulted as often as we'd like. And all of these things are related to one another. They one affects the other and how another should be construed. And so this set of regulations would combine all of those and elevate them all to the status of regulations, thus giving them the force of law, and again, placing them in one set of regulations where they're most likely to be consulted, even if someone is applying another regulation. So more specifically, it would combine and it would hopefully improve upon based on certain things that we've seen and comments that we've received over time, and it would supersede parts of the following. The April 2022 construction of Chapter 6E's scope, which elaborated on the meaning of law enforcement agency and law enforcement officer, because even though those terms are defined by the statute, we still saw room to elaborate further on exactly who is in scope and not in scope. It would also incorporate the definition of arrest and the restrictions on executing arrests and performing police duties and functions if one is without an active certification or is in certain other situations that are contained within 555 CMR 9, which was approved by the Commission and became effective in September 2023. It would also incorporate parts of the guidance on that set of regulations that the Commission approved in February of last year. And it would incorporate the draft guidance on police duties and functions and the draft guidance on heads and officers of law enforcement agencies that were put before the Commission last year or this year and have not yet been approved. And the reason that those have not yet been approved is that we've continued to collect feedback on those proposed sets of guidance from the people who would be most affected by them, as well as people within the Commission and people within the Municipal Police Training Committee. So looking at the specific sections of this proposed set of regulations, the first one deals with, or the first substantive one after the general section dealing with the framework of the regulations and their scope. The first section deals with definitions. So it includes, and I'll just highlight things that are particularly noteworthy. It includes the definition of arrest, as I said, that is contained in existing regulations, as well as a statement that the Commission approved in an advisory and a guidance that provided some more clarification on the meaning of an arrest. Then it would also define the term member in the sense of a member of a law enforcement agency in a broad way so that it would include those who might have an atypical employment relationship, those who might not be considered an employee, but who perform functions for that agency and where it would seem to make sense for those people to also be considered in scope, to be considered a part of the law enforcement agency and subject to regulation. So specifically the agency head, anyone who does have the status of an employee, an independent contractor, anyone who is an agent in the sense of agency law for that agency, and anyone who's subject to the agency's direction and control in relevant ways, or who works for some other entity that has a joint venture with the agency that we're looking at in relevant ways. And with respect to those last three things on the list, those are based on existing principles of Massachusetts law that relate to when someone who is not a regular employee of a particular entity will be treated the same as one who is a regular employee, and when that entity will be held responsible for that individual's conduct. And they're consistent, that broad definition, with the fact that the legislature included in the definition of law enforcement officers any other special, reserve, or intermittent police officer. So in other words, they signaled to us that they wanted to construe that definition broadly and that it should take into account anyone who might have some kind of special or atypical status, but who is nevertheless performing law enforcement duties for a law enforcement agency. So the next couple sections deal with the meaning of law enforcement agencies and law enforcement officers. And they elaborate on those terms in a way that's generally consistent with what the Commission approved in April 2022, which in turn was largely based on principles of statutory interpretation that have been elaborated on by judicial opinions over the years. And it also takes into account a change to the statute that was made later that year, which added Humane Society officers to the definition of law enforcement officers. But it does re-examine the test that the Commission previously approved for whether a part of a sheriff's office constitutes, and these are the words of the statute, a sheriff's department in its performance of police duties and functions. So under the statute, only that is included within the definition of law enforcement agency, and only the members of the sheriff's office who perform police duties and functions are considered law enforcement officers. So previously, the Commission approved a test which looked at whether that part of the office is a part that actually performs the full range of police duties and functions, including all types of arrests. But over time, that has continued to raise questions. It seems to have led to some confusion. And so it has never been quite as helpful as we would have hoped. And so this would replace that test with one that essentially does the following. It creates a presumption that the part of a sheriff's office qualifies, that it is the part that performs police duties and functions, but it invites the sheriff or a designee of the sheriff to attest that that's not the case, provided that the person can attest that the members are not authorized by the sheriff to execute arrests, they're not authorized to perform most other police duties and functions, and they don't devote a majority of their work time to the performance of police duties and functions. And the meaning of performing police duties and functions is also elaborated on within the STRAP set of regulations. I'll get to that in a minute. So in doing that, it gives the sheriff some flexibility, some input, and the ability to designate parts of the agency that should qualify. But at the same time, it still builds in a provision that reserves the ultimate determination for the post commission. Then, consistent with the construction of scope of Chapter 6E that the commission previously adopted, these sections would recognize the commission's ability to decide whether to include two other types of special state police officers who are not listed in Chapter 6E. There are two types that cannot be found in the definition of law enforcement agency or law enforcement officer within the commission's governing statute, but in their own statutes, that is, the statutes that define the powers and responsibilities of those special state police officers, it says that they shall receive such certification as the commission shall direct or have undergone certification as required by the post commission. So previously, the commission took the position that gives the commission the option, the discretion to decide whether to include those officers in scope. And so this set of regulations would do the same. And specifically, those are special state police officers who work for what is described as the Civil Defense Agency, meaning the Mass Emergency Management Agency, and the State Auditor's Office's Bureau of Special Investigations. Now, the next couple of sections deal with heads of law enforcement agencies and officers of law enforcement agencies, and they are largely consistent with certain things that were contained in the April 2022 construction of scope that the commission adopted, as well as the proposed guidance that we put before the commission last year and this year. So just by way of background, by way of reminder for anyone watching from the public, Chapter 6E defines a law enforcement officer as, including among other things, any officer of an agency, including the head of the agency. And it also, elsewhere in the statute, provides for an administrative suspension of the certification of the head of a law enforcement agency who fails to satisfy certain requirements regarding the submission of information to the post commission. So looking at those together, it does raise this question of, well, who is an officer of an agency? And it suggests strongly that the head of the agency must be that type of an officer, because it provides for the head of an agency to face an administrative suspension of their certification if they fail to meet certain requirements. So they must be a certified law enforcement officer. At least that must have been what the legislature contemplated. Otherwise, that enforcement mechanism just wouldn't work. But then it still creates this question about who is an agency head? What does that mean? So these sections seek to answer those questions, and they would provide that ordinarily an agency's head is the highest level individual who exercises day-to-day supervision and control of its law enforcement agency. And that's without regard to the person's specific title, whether they're considered an employee technically, and whether they are considered by that entity to be a sworn officer or to be a civilian. In other words, it takes a functional approach. It looks at the job function. What is the person actually doing? What is their role in relationship with the agency, as opposed to other formalities and titles? And it allows the post commission to require an agency to identify its agency head, and if they don't do so, for the commission to identify one. It would then go on to say that an officer of a law enforcement agency, because again, that person is included within the definition of law enforcement officer, but it's but it needs some elaboration. That includes any member of an agency or anyone who's affiliated with an agency who is the head of the agency, at least in ordinary cases, is the police officer, is authorized or tends to make arrests or to perform police duties and functions, or represents oneself as a law enforcement officer with the agency when they're interacting with the public. And you can see there on the slide that I corrected something in the draft set of regulations to be consistent with the intent. Now, they would add that the Post Commission can determine that another person is in fact an officer of an agency, and it lists a set of factors that may be found to weigh in favor of that determination. And again, that's consistent with a proposal that was put before the Commission previously. The next section deals with law enforcement powers, and it's generally consistent with a regulation that was previously approved and is in effect, and with something that was contained in one of those proposed sets of guidance dealing with police duties and functions. And it would affirm that none of those statuses that we've just discussed or someone's certification gives them any jurisdiction or powers beyond what was afforded before Chapter 60's enactment. And so it's intended to address some possible misperceptions. In other words, if somebody is certified, that means that they can do the job that they have based on all the powers and based on all the responsibilities that job entailed before Chapter 60's enactment. Obviously, if there's been some new statutory amendment since then, it would take that into account as well. But it's not the case that they have somehow broader powers, broader authority than they never had before. That doesn't seem to be what the statute intended. The statute intended a certification more as a license to do a job, not an expansion of everyone's powers. So the next section, as I alluded to before, it elaborates on the meaning of police duties and functions. It's largely consistent with what is contained in a regulation already in effect and with the proposed guidance on this subject. And it provides that the police duties and functions would be characterized in a way that's generally consistent with a definition that's contained in the MPTC's regulations. And we appreciated that they engaged in some discussion with us in developing those regulations so that we could be on the same page. And so this would ensure that the two agencies are on the same page. And it defines performing as either personally engaging in conduct or supervising or overseeing another's engaging in conduct. And it provides a list of police duties and functions that are based on statutory law and case law dealing with the position of a police officer, as well as some indications in legislative history about what the legislature intended. It would also restate and build on, as I said, an existing regulation by providing that generally one can be subject to sanctions for executing arrests or performing police duties and functions if they lack an active certification or they don't have the power to engage in that activity. And it lists potential sanctions, generally tracking those that are referenced in Chapter 6E. So in other words, if there is a type of sanction, a type of consequence that's already provided for in 6E, this set of regulations would say that a violation of this provision would be another basis to impose one of those sanctions. But it carves out certain exceptions for conduct that is otherwise lawful and necessary and is undertaken to defend against imminent harm to one's health or another, to ensure the safety and control of prisoners in transit, or due to other exigent circumstances. So it addresses a concern raised by some that somebody who maybe ordinarily wouldn't be allowed to exercise police duties and functions might be in some emergency situation where they absolutely need to, where it's necessary for public safety. And so this would carve out an exception for that kind of situation. The next section deals with law enforcement agency responsibility for individual conduct. And it's largely based on existing principles of vicarious liability, of when an entity like an employer can be held responsible for the actions of an individual like its employee or its agent. And so Massachusetts law provides, and so this regulation would provide, that the individual's conduct can be treated as the conduct of the entity where it's tolerated by a high-level agency official, or it's of the kind that an individual has been retained to perform or occurs substantially within authorized time and space limits and is motivated, at least in part, by a purpose to serve the agency. Actually, the Massachusetts law would provide even just that second set of factors would be enough. So this would essentially take those principles that are found in the law of vicarious liability and would incorporate them into the regulations. Then last, the regulations affirm what is already clear, I would say, from the governing statute, that the Post Commission can obtain information that it needs to make a determination under these regulations to determine whether these tests are met to the extent that that's allowed by law. So with that, I will stop sharing the screen and I can entertain any questions if the chair would like me to do so. Let me say, by the way, we're not putting this before the commission for a vote in this meeting, as is customary. We are introducing it now. We will accept any feedback from anyone inside or outside our agency, and then come back at an appropriate time if that seems to be if there seems to be sufficient support for this.
I don't think I see any hands in.
Well,
No, Commissioner
sorry.
Kazarosan, go ahead.
It's not really a question. I just want to say, I think this is a really comprehensive work that addresses a lot of issues that have caused a lot of confusion and a lot of problems. And I think this really does a great job in addressing what we've been dealing with over the last 4 years. So I just commend everyone who's been working on this. It's a wonderful, it's a great job. Well done.
Thank you very much.
Yes, I certainly share that, and I suspect my fellow commissioners do as well. So I don't think I see any hands in the air. Thank you very much, Randy, and those who have worked with you. And moving on, back to you, Randy.
Yes, I will now turn the floor over to Annie Lee.
Thank you, Randy, and good morning, Madam Chair and Commissioners. So today on agency certification, I will be presenting 2 items. The first is another proposed revision to the standard concerning internal affairs and officer complaint investigation procedures. Pending any further questions or feedback from you, I anticipate asking for your preliminary approval of the standard. And then second, following that discussion, I plan to present 2 proposals concerning requirements for agency certification for your consideration. I will not be asking for preliminary approval of any draft regulatory language, but rather your initial feedback and reactions. And so starting with the IA standard. This standard was last before you in May. During May's meeting, we reviewed proposed revisions concerning the bifurcation of investigation and discipline responsibilities in an IA investigation. Your feedback was that bifurcation should be presumed and essentially mandatory. And this was in order to ensure that IA investigations are sound and subsequent discipline bias-free. Based on your feedback, I've revised the bifurcation language, a copy of which is available in your packet starting at page 46 as follows. I revised it as follows. So this language just says, assignment of an IA investigation, which shall be to an employee of the agency or an outside investigator retained by the agency who is not responsible for imposing discipline, except where the basis for the IA investigation is a minor matter, as that term is defined in 555 CMR 1, which is the procedural rules. And so this revision seeks to do 2 things that the Commission had raised last month. The first is to clarify who is an appropriate and acceptable internal affairs investigator, and to second, strengthen the bifurcation of investigation and discipline responsibilities that's already implied in the Commission's regulations, while providing flexibility in minor matters that may otherwise pose budgetary and resource challenges to agencies. And so with that, I will stop sharing my slides briefly. I'm happy to answer any questions and take any reactions as you would like, Madam Chair.
Thank you, Annie. I don't think I see any questions from my fellow commissioners? So at this point, you are asking us to vote on this, correct?
Correct.
All right. Let me take a vote then, please. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
Commissioner Kazarosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley.
yes.
I'm also a yes, so that's unanimously carried. Thank you very much. I think we go back to you, Annie, for the next matter, please.
Yes, thank you. So the second item today relates to requirements for agency certification. As you'll remember, last month I presented a policy question for the Commission's consideration, which is when it comes to requirements for agency certification, should the Commission take into consideration an agency's past compliance with other laws, rules, and regulations? And so by way of background, this question arises because Chapter 6E, Section 5, directs the Commission to certify law enforcement agencies in at least 8 areas. And those are the standards that we've been talking about up until today. Chapter 6E, however, doesn't provide any further instructions. Among those omitted instructions is a lack of guidance as to what the requirements are for agency certification. And by lack of requirements, I mean that Chapter 6E does not address whether an agency need only institute written policies that meet the 8 certification standards that the Commission has approved, or whether the Commission should also require agencies to satisfy its obligations under all other sources of law in order to be certified by the Commission. And so to try to answer this question for you, today I'm presenting 2 proposals for your consideration. Of course, the Commission isn't limited to those 2 proposals. If there's a suggestion or an idea that the Commission would like to pursue that is not one of the 2 proposals I've put before you today, that is, of course, within the Commission's purview. But the 2 proposals that I have before the Commission, the first one is a limited scope of requirements for agency certification. So under the first proposal, an agency would only need to institute written policies that meet the requirements of this 8 certification standards that the Commission has approved. That means an agency's nonfeasance with its obligations under other sources of law would not factor into the Commission certification determination. And so while this is a somewhat limited scope of requirements for agency certification, this does track closely with Chapter 6E's similarly limited directives concerning agency certification. The second proposal before you today is a broader scope of requirements for agency certification. Under the second proposal, agencies would need to, in addition to instituting written policies that meet the requirements of the 8 agency certification standards, would also need to institute policies, directives, and/or practices that comply with all applicable obligations under all sources of law, regardless of whether those obligations come from Chapter 6E or elsewhere, in order to be certified by the Commission. So an example here is a requirement for an SRO memorandum of understanding. So under General Laws Chapter 71, Section 37PD, an agency with at least one SRO is required to have an MOU that is at a minimum consistent with a model MOU that has been developed by a model SRO MOU review commission. However, based on anecdotal reports, and there's a public comment letter included in your packet to this effect, there are some agencies with SROs that haven't adopted an MOU. And there are also some agencies that have adopted an MOU, but one that isn't consistent with the model MOU that the MOU SRO Review Commission has put out. And this is despite the statutory obligation set forth in Chapter 71, Section 37P. And so if the Commission were to adopt this broader scope of requirements under the second proposal, the Commission would be able to shore up agencies' compliance with other obligations as a condition to agency certification. This would support the legislature's goal of professionalizing and standardizing law enforcement throughout the Commonwealth, and also enable the Commission to fulfill its mission as a primary oversight authority of law enforcement in the Commonwealth. If the Commission were not to adopt this broader scope of requirements, it's not clear how agencies nonfeasance with obligations under other sources of law, like, for example, the requirement for an SRO MOU. It's not clear how that would be addressed or remedied. And furthermore, to the extent that Chapter 6E has limited directives concerning agency certification, you could also read Chapter 6E's silence to be interpreted to imbue the Commission with broad authority to establish the parameters of agency certification. I would suggest that this implicit grant would be consistent with the legislature's broad grant of powers to the Commission. At Chapter 6E, Section 3A, the Commission is imbued with all powers necessary or convenient to carry out and effectuate its purposes. And so my recommendation is the Commission adopt the second proposal, a broader scope of requirements for agency certification, but of course, happy to take any questions and field reactions the Commission may have at this time. Thank you.
Commissioner Baker?
Yeah, good morning. We tackled this a while ago in a subgroup, and I think it's a great idea. I don't know how we can add this if possible. I agree with you. I believe in accreditation and certification, and that was one of the things that the group put together is meeting those standards for certification. If we're going to take that broader, you have some agencies that just don't have the personnel to have an accreditation manager or to have somebody full-time to stay on top of that. If the Commission is going to go that route, there needs to be some type of portal that if an agency is lacking in a certain area and they need help to get that policy, that we are able to provide them a policy that will bring them up to date. Especially, like I said, an agency that just can't deviate from their day-to-day operations. But I think if we're going to provide the resources for everyone to be in compliance without putting a burden on them that they don't have in their budget, then I don't see where this is wrong. And like I said, the group we got together, we felt that meeting the minimum of being certified was a great start. I just wanted to add that. Thank you.
Thank you. Commissioner Kajirosian?
Thank you. I agree with Commissioner Baker. I think that's a great idea, and I think that's something we could probably provide, I hope. This whole thing just seems to solidify already existing statutory obligations for agencies, and still allows us oversight. So I think this is a great step toward consistency throughout the agencies throughout the Commonwealth, and I think it's a really important step to take, so I support it wholeheartedly.
Thank you. Commissioner Bluestone?
Yes, thank you. I obviously think it's difficult to say that we shouldn't strive for the higher standard, but I do share the concern that Commissioner Baker raises about the administrative burden on agencies and wonder about the timing of implementation. So I think that would be my concern is, are agencies really ready for that higher standard? And is there a way to maybe implement it in iterations rather than as a single fairly dramatic change for some agencies that may not be prepared?
Thank you. Commissioner Talley?
Thank you, Chair. I agree with Commissioner Baker. I guess I just wanted to add, we probably should also include what type of help that we would provide instead of just leaving it open. Whatever help or assistance we can provide to smaller agencies that may not have the staff and or resources to move it up to the standard.
Thank you. And Commissioner Kajirosian again?
Sorry. I just want to make sure I understand. What I heard was basically that this is not going to impose any additional obligations or requirements on agency. It's just what it will do is provide post the ability to give oversight or to continue oversight on the agencies and provide consistency as far as our oversight through agencies. Is that fair to say, Annie?
Yes, I think that's correct.
Thank you. Enrique?
Yes, if I could just make a comment on the point about helping agencies rather than let's say a punitive approach. I think we could easily formulate something like what the Office of the Inspector General does in their oversight of a number of things like procurement of agencies of cities and towns. They tend to think of everything they do as a 50-50. There's an audit component, but there's the most important that they highlight, there's an educational component on everything that they do. So I think it's fair to state that we could, as we think about the process for agency certification, also termed in other ways as an audit program, we would very much implement such an approach.
Thank you as well. Any other questions or comments? Annie, anything further that you wish to add, given the comments?
Not at this time. This is incredibly helpful. I'll be back before the commission with this feedback incorporated.
Thank you. Thank you very much, and those who worked with you for your very hard work in putting this together. Next, Randy or Annie, anything further from a legal perspective?
No, thank you.
Thank you. I don't think there are any matters which were not anticipated by me at the time of posting. So at this point, I would entertain a motion to go into executive session in accordance with General Laws, Chapter 38, Section 21A1, to discuss the discipline or the dismissal of, or complaints or charges brought against a public officer, employee, or individual under the same statute, but Section 21A3, to discuss strategy with respect to litigation, as an open meeting may have a detrimental effect on the litigating position of the public body. Under Section 21A5 of Chapter 38, to discuss the investigation of charges of criminal misconduct. Under Section 21A7 of General Laws, Chapter 38, combined with General Laws, Chapter 6E, Section 8C2, and to the extent they may be applicable, General Laws, Chapter 6, Sections 168 and 178, to discuss matters relating to preliminary inquiries and initial staff review concerning whether to initiate such inquiries and regarding certain criminal record information consistent with 555 CMR 104A and General Laws, Chapter 38, Section 21A7, combined with Sections 22F and G of the same statute, to discuss and to approve prior executive session minutes. We will be addressing 3 standards reports of preliminary inquiries in executive session. We will be addressing 1 standards request to enter voluntary decertification, suspension, or disposition agreement, and we will be addressing 7 standards requests for approval to conduct preliminary inquiries and or impose a suspension in 7 cases. We will be also addressing a suspension hearing in the matter of Lakeisha Horsley, case number 2025-044, and we will be addressing the discussion of strategy in the matter of the law offices of Howard Friedman versus the Post Commission, which was civil action number 2584 CV02072 in the Suffolk County Superior Court, and we will be addressing the approval of minutes of the prior executive session of May 21 of this year. Is there a motion to go into executive session?
So moved.
Is there a second?
Second.
Thank you. Commissioner Baker?
Yes.
Commissioner Blue, I'm not sure who made the motion, so I'm going to go through each of the commissioners on this. Commissioner Bluestone?
Yes.
Commissioner Crispin?
Yes.
Commissioner Hall?
Yes.
Commissioner Kasrosian?
Yes.
Commissioner Luma?
Yes.
Commissioner Talley?
Yes.
I'm also a yes, so that's unanimously carried by those in attendance. Let me thank all the members of our staff for the extraordinary work that they've engaged in putting together the materials that the public and we have had a chance to review. We are grateful to you for all that you've done. Those who have addressed us today, we're very grateful for that as well. Let me instruct the members of the public. Not only are we grateful for your attendance, but let me tell you, we will not be returning to the public meeting at the end of our executive session. Enrique, would you like again to please remind the members of the public how they can communicate with us about the matters that we have addressed if they wish to?
Yes, you can send us an email at postc-comments@mass.gov or visit our website, mapostcommission.gov.
Thank you very much. And with that, commissioners, we will take a 5-minute break before we go into executive session. I think the Zoom information has again been, Jamie, it's been reposted, correct?
We sent it around a few minutes ago, yeah.
Okay, thank you very much. And with that, we'll reconvene in executive session in approximately 5 minutes.